Please subscribe, like and share this content. It means a lot to us. Thank you in advance.
Cornell Law School.
U.C.C. Article 9. Secured Transactions.
Part 6. Default. Subpart 1. Default and Enforcement of Security Interest. Paragraph 9601. Rights after default. Judicial enforcement. Consignor or buyer of accounts, chattel paper, payment intangibles, or promissory notes. A. Rights of secured party after default. After default, a secured party has the rights provided in this part and, except as otherwise provided in Section 9602, those provided by agreement of the parties. A secured party 1. May reduce a claim to judgment, foreclose, or otherwise enforce the claim, security interest, or agricultural lien by any available judicial procedure, and 2. If the collateral is documents, may proceed either as to the documents or as to the goods they cover. B. Rights and duties of secured party in possession or control. A secured party in possession of collateral or control of collateral under Section 9104, 9105, 9106, or 9107 has the rights and duties provided in Section 9207. C. Rights cumulative. Simultaneous exercise. The rights under subsections A and B are cumulative and may be exercised simultaneously. D. Rights of debtor and obliger. Except as otherwise provided in subsection G and Section 9605, after default, a debtor and an obliger have the rights provided in this part and by agreement of the parties. E. Lien of levy after judgment. If a secured party has reduced its claim to judgment, the lien of any levy that may be made upon the collateral by virtue of an execution based upon the judgment relates back to the earliest of 1. The date of perfection of the security interest or agricultural lien in the collateral. 2. The date of filing a financing statement covering a collateral, or 3. Any date specified in a statute under which the agricultural lien was created. F. Execution sale. A sale pursuant to an execution is a foreclosure of the security interest or agricultural lien by judicial procedure within the meaning of this section. A secured party may purchase at the sale and thereafter hold the collateral free of any other requirements of this article. G. Consignor or buyer of certain rights to payment. Except as otherwise provided in Section 9607 C, this part imposes no duties upon a secured party that is a consignor or is a buyer of accounts, chattel paper, payment intangibles, or promissory notes. Paragraph 9602. Waiver and variance of rights and duties. Except as otherwise provided in Section 9624, to the extent that they give rights to a debtor or obliger and impose duties on a secured party, the debtor or obliger may not waive or vary the rules stated in the following list of sections. 1. Section 9207, B, 4, C, which deals with use and operation of the collateral by the secured party. 2. Section 9210, which deals with requests for an accounting and requests concerning a list of collateral and statement of account. 3. Section 9607, C, which deals with collection and enforcement of collateral. 4. Sections 9608A and 9615C, to the extent that they deal with application or payment of non-cash proceeds of collection, enforcement, or disposition. 5. Sections 9608A and 9615D, to the extent that they require accounting for or payment of surplus proceeds of collateral. 6. Section 9609, to the extent that it imposes upon a secured party that takes possession of collateral without judicial process the duty to do so without breach of the peace. 7. Sections 9610, B, 9, 611, 9613, and 9614, which deal with disposition of collateral. 8. Section 9615, F, which deals with calculation of a deficiency or surplus when a disposition is made to the secured party, a person related to the secured party, or a secondary obliger. 9. Section 9616, which deals with explanation of the calculation of a surplus or deficiency. 10. Sections 9620, 9621, and 9622, which deal with acceptance of collateral and satisfaction of obligation. 11. Section 9623, which deals with redemption of collateral. 12. Section 9624, which deals with permissible waivers, and 13. Sections 9625 and 9626, which deal with the secured party's liability for failure to comply with this article. Paragraph 9603. Agreement on standards concerning rights and duties. A. Agreed standards. The parties may determine by agreement the standards measuring the fulfillment of the rights of a debtor or obligor and the duties of a secured party under a rule stated in Section 9602 if the standards are not manifestly unreasonable. B. Agreed standards inapplicable to breach of peace. Subsection A does not apply to the duty under Section 9609 to refrain from breaching the peace. Paragraph 9604. Procedure if security agreement covers real property or fixtures. A. Enforcement. Personal and real property. If a security agreement covers both personal and real property, a secured party may proceed 1. Under this part as to the personal property without prejudicing any rights with respect to the real property, or 2. As to both the personal property and the real property in accordance with the rights with respect to the real property, in which case the other provisions of this part do not apply. B. Enforcement. Fixtures. Subject to subsection C, if a security agreement covers goods that are or become fixtures, a secured party may proceed 1. Under this part, or 2. In accordance with the rights with respect to real property, in which case the other provisions of this part do not apply. C. Removal of fixtures. Subject to the other provisions of this part, if a secured party holding a security interest in fixtures has priority over all owners and encumbrances of the real property, the secured party, after default, may remove the collateral from the real property. D. Injury caused by removal. A secured party that removes collateral shall promptly reimburse any encumbrancer or owner of the real property, other than the debtor, for the cost of repair of any physical injury caused by the removal. The secured party need not reimburse the encumbrancer or owner for any diminution in value of the real property caused by the absence of the goods removed or by any necessity of replacing them. A person entitled to reimbursement may refuse permission to remove until the secured party gives adequate assurance for the performance of the obligation to reimburse. Paragraph 9605. Unknown debtor or secondary obligor. A secured party does not owe a duty based on its status as secured party 1. To a person that is a debtor or obligor, unless the secured party knows A. That the person is a debtor or obligor, B. The identity of the person, and C. How to communicate with the person, or 2. To a secured party or lien holder that has filed a financing statement against a person, unless the secured party knows A. That the person is a debtor, and B. The identity of the person. Paragraph 9606. Time of default for agricultural lien. For purposes of this part, a default occurs in connection with an agricultural lien at the time the secured party becomes entitled to enforce the lien in accordance with the statute under which it was created. Paragraph 9607. Collection and enforcement by secured party. A. Collection and enforcement generally. If so agreed, and in any event after default, a secured party 1. May notify an account debtor or other person obligated on collateral to make payment or otherwise render performance to or for the benefit of the secured party. 2. May take any proceeds to which the secured party is entitled under Section 9315. 3. May enforce the obligations of an account debtor or other person obligated on collateral and exercise the rights of the debtor with respect to the obligation of the account debtor or other person obligated on collateral to make payment or otherwise render performance to the debtor, and with respect to any property that secures the obligations of the account debtor or other person obligated on the collateral. 4. If it holds a security interest in a deposit account perfected by control under Section 9104A1, may apply the balance of the deposit account to the obligation secured by the deposit account, and 5. If it holds a security interest in a deposit account perfected by control under Section 9104A2 or 3, may instruct the bank to pay the balance of the deposit account to or for the benefit of the secured party. B. Non-judicial enforcement of mortgage. If necessary to enable a secured party to exercise under subsection A3 the right of a debtor to enforce a mortgage non-judicially, the secured party may record in the office in which a record of the mortgage is recorded 1. A copy of the security agreement that creates or provides for a security interest in the obligation secured by the mortgage, and 2. The secured party's sworn affidavit in recordable form stating that A default has occurred with respect to the obligation secured by the mortgage, and B. The secured party is entitled to enforce the mortgage non-judicially. C. Commercially reasonable collection and enforcement. A secured party shall proceed in a commercially reasonable manner if the secured party 1. Undertakes to collect from or enforce an obligation of an account debtor or other person obligated on collateral, and 2. Is entitled to charge back uncollected collateral or otherwise to full or limited recourse against the debtor or a secondary obliger. D. Expenses of collection and enforcement. A secured party may deduct from the collections made pursuant to subsection C reasonable expenses of collection and enforcement, including reasonable attorney's fees and legal expenses incurred by the secured party. E. Duties to secured party not affected. This section does not determine whether an account debtor, bank, or other person obligated on collateral owes a duty to a secured party. Paragraph 9608. Application of proceeds of collection or enforcement, liability for deficiency and right to surplus. A. Application of proceeds, surplus, and deficiency if obligation secured. If a security interest or agricultural lien secures payment or performance of an obligation, the following rules apply. 1. A secured party shall apply or pay over for application the cash proceeds of collection or enforcement under Section 9607 in the following order to A. The reasonable expenses of collection and enforcement and, to the extent provided for by agreement and not prohibited by law, reasonable attorney's fees and legal expenses incurred by the secured party. B. The satisfaction of obligations secured by the security interest or agricultural lien under which the collection or enforcement is made, and C. The satisfaction of obligations secured by any subordinate security interest in or other lien on the collateral subject to the security interest or agricultural lien under which the collection or enforcement is made if the secured party receives an authenticated demand for proceeds before distribution of the proceeds is completed. 2. If requested by a secured party, a holder of a subordinate security interest or other lien shall furnish reasonable proof of the interest or lien within a reasonable time. Unless a holder complies, the secured party need not comply with the holder's demand under paragraph 1c. 3. A secured party need not apply or pay over for application non-cash proceeds of collection and enforcement under Section 9607 unless the failure to do so would be commercially unreasonable. A secured party that applies or pays over for application non-cash proceeds shall do so in a commercially reasonable manner. 4. A secured party shall account to and pay a debtor for any surplus, and the obliger is liable for any deficiency. B. No surplus or deficiency in sales of certain rights to payment. If the underlying transaction is a sale of accounts, chattel paper, payment intangibles, or promissory notes, the debtor is not entitled to any surplus, and the obliger is not liable for any deficiency.